Contemporaneous legal discourse is often paralyzed with substantive arguments that both oppose and favor a particular question of law from seemingly equally merited standpoints. Illegality is a podcast that delves into often conflicting but equally incontrovertible aspects of legal discussion and provides listeners the opportunity to know all schools of thought governing legal issues. From the Journal and Seminar Committee of Department of Law, University of Calcutta, and co-hosted by Atru Chakraborty and Samrita Sen.
Hello everyone, welcome to Illegality, the weekly podcast of the Journal and Seminar Committee of the Department of Law, University of Calcutta, co-hosted by Atru Chakraborty and I, Samrita Sen, where we delve into the merits of conflicting arguments in legal discourse. For the second episode, we have adopted an unconventional format where every alternate weekly episode of the podcast will be co-hosted by volunteering general members of the committee. In today's episode, general members Anogh Chakraborty and Shubhayan discuss the ethical role of the medical professionals and the subsequent duty towards patients during a pandemic influenza when it exposes the workers themselves to a significant risk of physical harm or even death, and how far shall the discretion of the doctors during such medical emergency be kept out of legal check.
Hello listeners, I, Anogh Chakraborty, and my friend Shubhayan today will address one of the least discussed legal issues of socio-medical aspect.
Here in this episode, we shall indulge in a dialogue and discuss upon the ethical and legal obligations of medical professionals during a situation of medical emergency.
I will introduce you to the topic and further discuss on the ethical and legal arguments.
Whereas I will address the intricacies of the concept of duty to care and finally conclude by justifying the role of the state in the concerned matter. The topic of this episode is discussion on ethical and legal obligations of medical professionals during pandemic and their subsequent duty to care.
In 2003, during the SARS outbreak, approximately 30% of the reported cases were among healthcare workers. And in Toronto of Canada alone, slightly less than half of the 182 cases involved health professionals. 3 of those professionals died after exposure. The University of Toronto Joint Center for Bioethics Pandemic Influenza Working Group in 2005 has also reported that while many healthcare workers gave their all in treating the sick, others refused to show up for work and were dismissed as a result, and that there is enough reason to believe that this pattern would continue in the presence of an influenza pandemic. A survey in 2005 of the workers in public health agencies in Maryland also revealed that almost half of them indicated that they would not report for duty during a pandemic. Pellegrino and Thomasma, in their book For the Patient's Good, devoted a chapter to the good patient. Patients, they write, must relate to physicians in all of the virtuous ways that govern human interrelationships and social conduct. They identified 4 key virtues for the good patient, namely truthfulness, compliance, tolerance, and trust. The virtue most pertinent to this discussion is tolerance. The examination of tolerance indicates the patient's need to understand the limitations and fallibility of medicine and to care for the well-being of their fellow men. The virtue of tolerance should also require patients to acknowledge healthcare workers' plurality of roles, as well as their fears and concerns in the face of severe risk. If these fears are well-founded and reach such a level that medical staff are worried for their life or that of their loved ones, the virtuous patient ought to allow them to step down from their role as caregivers. In such cases, insisting that they continue in this role would reflect a lack of compassion and understanding. The problem here arises is that this compassionate and understanding attitude of the patients would no doubt prove derogatory to their health, and especially in times of epidemics and pandemics, can be even a possible threat to their lives. It is an obvious expectation that a patient cannot comply with his principles when his life is at stake, and the only hope remaining at this point is his doctor. Hence, this discussion shall focus on the role of caregivers in the situations of emergent socio-medical concern. Before analyzing this issue in detail, it is important to understand the meaning of certain terms. In epidemiology, an outbreak is referred to a sudden increase in occurrences of a disease in a particular time and place. An epidemic disease is one affecting many persons at the same time and spreading from person to person in a locality where the disease is not permanently prevalent. WHO further specifies epidemic as occurring at the level of a region or community. A pandemic disease is an epidemic that has spread over a large area. That is, it is prevalent throughout an entire country, continent, or the whole world even. The demic part of the word epidemic and pandemic comes from the Greek word demos, meaning people of a district. In addition, it will be interesting to know that this root, the demic part, also ultimately gives English the word democracy. Currently, most of the world is under lockdown due to the widespread outburst of SARS-CoV-2, popularly known as COVID-19. And as this podcast is being recorded, over 1,14,000 people have succumbed to their death, and almost 13,15,000 patients are fighting their battle with the fatal coronavirus. Thus, it is important to determine whether the caregivers will be bound by their duty to care for their patients in times of pandemics, when doing so exposes the workers themselves to significant risk of physical harm or even death. We will also address the question as to how far shall the discretion of the doctors in times of such medical emergencies be kept out of legal check.
The most pertinent thing that needs to be understood in this context is the term duty to care. Generally, in tort law, a duty of care is a legal obligation which is imposed on an individual requiring adherence to a standard of reasonable care while performing any acts that could forcibly harm others. But due to the wide ambit and lack of medical definition of the term duty to care, a state of confusion emerges internationally. While it can be easily asserted that the healthcare workers individually enter this profession knowing the duties they are expected to perform and the obligations they are bound by, but the laws make it a little more complicated than that. For example, if a chart of comparison is drawn between the functioning of a medical professional and a soldier, despite having wide-ranging dissimilarities in the nature of the two jobs, much variance won't be found in their purposes, which in essence both calls for their services towards humanity at large. Hence, it's extrapolating this context, it can also be questioned why the healthcare workers' responsibilities should be curtailed with reasonableness when soldiers who flee from the battlefront are court-martialed. What is presently pertinent is to raise this question whether the healthcare workers should be taken as being bound by their duty to care individually or as a group. The debate was initially robust, but with time, various groups came to the conclusion that the relevant healthcare workers could not reject patients on the ground that they had HIV, and this view was codified within a variety of official statements. For example, the American Nursing Association's position statement on risk versus responsibility, revised in 1994, states that nursing is resolute in its position that care should be delivered without prejudice, and it makes no allowance for use of the client's personal attributes, socioeconomic or health status as grounds for discrimination. And the 2002 edition of the American College of Physicians Ethics Manual states that the denial of appropriate care to a class of patients for any reason, including disease state, is unethical. Before establishing whether or not a healthcare worker is unconditionally obligated to treat a patient, it should be established where the difference between the job of a healthcare worker and the respective duties of any other professional's profile, including such work that aims towards safeguarding people physically, lies. The phrase duty to care is often understood as the duty of a doctor or any healthcare worker towards an individual patient, but according to Regulation 1.2.1 of the Code of Medical Ethics Regulations 2002, made under Section 33 of the Indian Medical Council Act 1956, a medical professional's duty is towards the humanity at large. Although it is not mentioned explicitly in Indian medical laws whether a professional has to serve the sick, risking his own life in case of an epidemic. He is not bound to serve an individual under the code, but doing so, his morality would be expected to be discountenanced in his professional fraternity as well as by the public in case of non-fulfillment of his call of duty. From a bigger perspective, a medical professional may be needed by more than one person. Therefore, it is merely for a greater good if duty is not considered in a narrow manner. Galen, the famous physician, was reported to have fled from Rome during the incurable Antonine Plague in 166 AD. Although in the 14th century some physicians stayed and cared for the sick, but most responded to the Black Death by fleeing. Defoe indicates that most physicians were called deserters in A Journal of the Plague Year, a novelistic chronicle about London's Great Plague of 1665. In the mid-19th century, nascent professional organizations began to articulate the physician's ethical obligation to care for the sick during epidemics. Before the current coronavirus outbreak, several plagues and outbreaks such as the SARS, the avian flu, the bubonic plague, the cholera, Ebola, etc. have tested and prepared humanity for the most gruesome emergencies. This simple discussion is the unflinching care of the doctors and healthcare professionals towards their patients that distinguishes them from the lawyers, businessmen, and teachers. As this topic created national debates by the end of the HIV epidemic in America, most of the members of this fraternity sided with the argument that doctors should be free to select their patients, but by the time SARS struck America, ethics of the doctors shifted in the spectrum, accounting for a sufficient number of healthcare volunteers. The Declarations of Geneva, World Medical Association, reads that as a member of the medical profession, a person shall pledge to dedicate his life to the service of humanity, and he will not permit considerations of age, disease or disability, creed, ethnic origin, gender, nationality, political affiliation, race, sexual orientation, social standing, or any other factor to intervene between one's duty and one's patient. But the WMA Declaration of Seoul on Professional Autonomy and Clinical Independence, adopted in 2008 and amended by the 69th WMA General Assembly held in Reykjavik, Iceland in October 2018, reaffirms that professional autonomy and clinical independence are essential components of high-quality medical care, and the patient-physician relationship must be preserved. The WMA also reaffirms that professional autonomy and clinical independence are core elements of medical professionalism. Although different organizations have different approaches towards medical ethics as humanity moves forward in time, individualism is given a higher priority due to the lack of a middle ground on what the appropriate definition of the phrase duty to care actually is. A review of published codes of ethics found that professional codes employed variable wording regarding duty to care. Few contain direct language addressing infectious diseases as emergency. Till date, 61 professional codes have been reviewed, 29 codes had no mention, 23 had broad statements, and 8 had what could be construed as specific direction to members. A good example of this would be the AMA policy document, Physician Obligation in Disaster Preparedness and Response, adopted in June 2004, which articulated that national, regional, and local responses to epidemics, terrorist attacks, and other disasters require extensive involvement of physicians. Individual physicians have an obligation to provide urgent medical care during disasters because of their commitment to care for the sick and injured. This ethical obligation holds even in the face of greater than usual risks to their own safety, health, or life. The physician workforce, however, is not an unlimited resource. Therefore, when participating in disaster responses, physicians should balance immediate benefits to individual patients with ability to care for patients in the future. If there stands an obligation in any code of ethics or in any authoritative medical literature or cases, it must be broken down to the medical professional's specialization. Therefore, a doctor who specializes in epidemiology does not extend his limits, but the job of treating a patient with a virulent infectious disease comes under his exact job profile. Hence, he consents either explicitly or tacitly to working in a stressed situation, which may even be a threat to his life. If a medical professional with a specialization remotely related to that of epidemiology is instructed to treat and look after a sea of patients, he should most likely be given the option to bail out. In most of the medical ethics codes and regulations, as well as the Hippocratic Oath, a medical professional who is likely to be underqualified to perform his expertise on a patient is rather advised to refrain from recommending any medical solutions at all, as it may risk the patient's well-being. But in a situation of epidemic, when a regular doctrine of specialized doctors is not enough and the number has to multiply to tackle the rising numbers of patients, the narrow set of principles in the codes should be interpreted in a way that offers a greater scope. Doctors have died while treating patients affected with the deadly COVID-19. As the medical capabilities of the countries are challenged individually, it is high time that every country decides upon whether their national health codes stand amended with the inclusion of necessary clauses after the consideration of catastrophic epidemics. The official curriculum of most of the medical schools around the world lack training programs teaching their students how to act in case of an epidemic. When the lack of knowledge is added with the lack of adequate medical equipment, it creates a huge panic for the general public and the medical professionals as well. The more this cavity is filled, the less will be the fear of being exposed.
Chapter 2 of the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002 states the duties of the physicians to their patient. Regulation 2.1.1 of the Code, under title Obligations to the Sick, reads, though a physician is not bound to treat each and every person asking his services, he should not only be ever ready to respond to the calls of the sick and the injured, but should be mindful of the high character of his mission and the responsibility he discharges in the course of his professional duties. In his treatment, he should never forget that the health and the lives of those entrusted to his care depend on his skill and attention. A physician should endeavor to add to the comfort of the sick by making his visits at the hour indicated to the patients. A physician advising a patient to seek service of another physician is acceptable. However, in case of emergency, a physician must treat the patient. No physician shall arbitrarily refuse treatment to a patient. However, for good reason, when a patient is suffering from an ailment which is not within the range of experience of the treating physician, the physician may refuse treatment and refer the patient to another physician. Regulation 2.2 talks of patience, delicacy and secrecy that has to be maintained by a physician while treating his patient. It mentions that patience and delicacy should characterize the physician. Sometimes, however, a physician must determine whether his duty to society requires him to employ knowledge obtained through confidence as a physician to protect a healthy person against a communicable disease to which he is about to be exposed. In such instances, the physician should act as he would wish another to act towards one of his own family in like circumstances. Regulation 2.4 ethically obligates the physician against any act of negligence towards his patient. It states, a physician is free to choose whom he will serve. He should, however, respond to any request for his assistance in an emergency. Once having undertaken a case, a physician should not neglect the patient, nor should he withdraw from the case without giving adequate notice to the patient and his family. Provisionally or fully registered medical practitioners shall not willfully commit an act of negligence that may deprive his patient or patients from necessary medical care. The greatest trouble, however, lies in the question that if there is an ethical failure in a country in case of an epidemic, will the legal system be able to hold the professionals accountable to such failure? The discretional laxity is likely to have greater positive impact on the psychology of a healthcare professional. And this in turn is likely to end a crisis if they are provided with the right authoritative capacity, which is also a show of trust. This argument is, however, myopic, as doctors may be rash at times of such crisis if they have no legal guidelines as appropriate railroads for their decisions, since not all professionals have the decisiveness to tackle a crisis situation. The Indian Penal Code expressly declares no such provision where a physician or any medical caregiver shall be held with criminal liability due to the non-fulfillment of his duty to care. The reason behind such exemption of liability for the doctors that can be reasonably understood is because the Indian criminal laws consider the duty to care as an ethical duty rather than a legal one. But however, in a pandemic crisis, the circumstances vary widely. Currently in India, as the treatment of the virus affected patients are done free of cost, not only the payment of the physicians are carried away by the state, but the doctors are also working and serving the society on behalf of the state. In this connection, it becomes important to determine the legal placing of these physicians, especially in their relation with the state. The question simply put is whether the physician serving the society on behalf of the state is serving in the capacity of a public servant for the time being. To determine this issue, it is important to understand the definition of public servant. According to Section 21 of the Indian Penal Code, every officer of the government whose duty it is to protect the public health, safety and convenience can be referred to as public servant. It also declares any person as a public servant who is A. in the service or pay of the government or remunerated by fees or commission for the performance of any public duty by the government, or B. in the service or pay of a local authority, a corporation established by or under a central, provincial or state act, or a government company as defined in section 617 of the Companies Act 1956. Public servant, as defined in P. Ramanatha Iyer's legal dictionary, is any person in the service or pay of the government or remunerated by the government by fees or commission for the performance of any public duty. Hence, it is prevalent from these definitions that the disposal of a public duty is a must for someone to be a public servant. Section 2 Clause B of the Prevention of Corruption Act 1988 defines public duty as a duty in the discharge of which the state, the public or community at large has an interest. The explanation to this section reads, in this clause, state includes a corporation established by or under a central, provincial or state act, or an authority or a body owned or controlled or aided by the government or a government company as defined in section 617 of the Companies Act 1956. Thus, from the given definitions of public duty, it is clear that the private medical practitioners, that is, the medical practitioners who are not appointed, paid, employed, hired or directed by state or any of its bodies cannot be considered as public servants as to the meaning of IPC or to the meaning of Prevention of Corruption Act for that matter. Merely responding to a request by the state to treat patients shall not be considered as to be serving in the capacity of a public servant. Now, as to determine who all, other than private practitioners, are to be held as public servants, reference may be made to the case of State of Maharashtra versus Dr. Rustam Franroz Hakim, where the Division Bench of Bombay High Court declared that an appointed panel of doctors by a certain corporation cannot be held as public servants within the meaning of Section 21 of IPC. The court relied on a number of judgments to substantiate its ruling. Among them, a 1968 Calcutta High Court judgment of the case Dr. Nanigopal Ghosh versus State of West Bengal was also referred to, where the division bench gave 5 point-wise reasons defining why a panel of doctors appointed by a corporation cannot be held as public servants. The court observed that 1. The remuneration which is payable to the insurance medical practitioner is paid not by the state government or out of the funds of the state, but is paid out of the contributions of the employers of the insured persons and the corporation. 2. A panel doctor gives nothing more than a voluntary undertaking to offer services in lieu of fees for professional service rendered, and the inclusion of the names in the list of panel doctors and the preparation of the list does not have the effect of making the medical practitioner an employee of the state. 3. The removal of such a panel doctor does not amount to removal from service but removal from the medical list of the panel doctors. 4. The corporation is a body corporate and is not the same as the state government. And 5. The contract between the medical practitioner and the corporation is a mere contract for services and not a contract of service. Therefore, only the government doctor, that is a civil servant, recruited through combined medical services exams such as Indian Ordnance Factory Health Service, Central Government Health Service, medical officer in railway, etc., can only be referred to as a public servant. And wherefore any breach of duty occurs through an act or omission as against direction of the state government by such public servant, he shall be criminally liable under section 174 of the Indian Penal Code. But it is a well-settled principle of common law that in order to constitute a crime, mens rea is an essential ingredient. It is the guilty mental element of a person's intention to commit a crime. In other words, what was the defendant's mental state and what did the defendant intend when the crime was committed is a matter of concern. Mens rea allows the criminal justice system to differentiate between someone who did not mean to commit a crime and someone who intentionally set out to commit a crime. Any unlawful act is considered to be a criminal act only when the person who commits it acts with criminal intent. The maxim actus non facit reum nisi mensit rea has, however, no application in its technical sense to the offences under our penal code, as the definitions of various offences contain expressly a proposition as to the state of mind of the accused. Each offence under the penal code prescribes a mens rea of a specific kind, which is not exactly same as mens rea in the sense of being a guilty mind under the common law. Throughout the code, the doctrine of mens rea runs as a continuous thread in the form of intentionally, voluntarily, knowingly, fraudulently, dishonestly, and the like. Section 174 prescribes punishment against the offender for his intentional commission of any act or omission derogatory to the direction of his authority. In this case, the intentional act of commission or omission by that public servant is done in the fear of danger to his own life and not with a malafide intention of causing harm or trouble. Hence, it is reasonable to say that such act should not impose punishment and be exempted from criminal liability under the provisions of general exceptions of the Indian Penal Code. In exchange for their work, doctors receive benefits from society, including high status, public respect, and some receive even substantial financial rewards. It is a fact that some specialties are more exposed to risk than others, and rewards are higher in senior members of the profession, yet junior medics and nurses may be at greater risk of infection than senior staff due to more frequent exposure. The same applies to paramedics and community teams, who will care for sick patients outside the hospital. From a nursing perspective, most codes of ethics expect that nurses should make the care of their patients their first concern. Interestingly, the UK Nursing and Medical Council states that nurses have both a legal and professional duty of care. A court of law could find a nurse negligent if a person suffered harm because they neglected to care for them adequately. Jacques Rousseau, in his popular work, The Social Contract, has coined the theory of social pact. He, with a generalizing mindset, hypothesizes that man in a society feels obligated to play his part in keeping that society working through his part of the contribution and agreeing to uphold the values of the same by being simply dutiful. However, it would be merely illusionary for the society or simply public at large to attempt to enslave the will of doctors and other healthcare professionals to treat them. This may be the reason why state has not imposed any legal solutions to harness the savior's willingness to treat. It would rather be logically fruitful if the government, as the representative of the people, provides such adequate knowledge and material equipment to the doctors so that they feel dutiful morally rather than obligated legally. The very nature of being a clinician entails a duty of beneficence to patients. Hence, even in absence of criminal liability, the moral priority of the doctors proves to be of greater obligation in the discharge of their ethical public duty. In high-risk emergency situations, such as in epidemics or bioterrorist attacks, the doctor is subject to a number of competing duties. Those duties can be listed as a duty to patients, a duty to protect oneself from undue risk of harm, a duty to one's family, a duty to colleagues whose workloads and risk of harm will increase in one's absence, and a duty to society. The profession, when considered as a whole, has an implicit contract with society to provide medical help in times of crisis. This can raise several questions, like what is an acceptable level of risk to the healthcare professional, or when does the risk cease to be reasonable and who should decide it? Professional organizations offer some guidance. For example, the UK General Medical Council advises in good medical practice, doctors must not refuse to treat patients because their medical condition may put the doctor at risk. The balance between protecting individual doctors and their families from harm and ensuring patients are not put at unnecessary risk is best addressed at local level, taking into consideration the principle that those who place themselves at additional risk should be supported in doing so and the risks and burdens minimized as far as possible. The American Medical Association, in its code of ethics, adds a longer-term perspective. It states, physicians should balance immediate benefits to individual patients with their ability to care for that patient in future.
As India finds itself in a state of emergency amidst the deadly COVID-19 pandemic, the state has taken it upon itself to test the suspects free of cost. However, it may seem as an unprecedented and noble gesture of the state, it is obligatory on their part to provide healthcare services since a patient has the right to healthcare facilities under Article 21 of the Constitution of India, as reiterated several times by the Supreme Court and different high courts as well. In the case of Bandhwa Mukti Morcha versus Union of India, the Supreme Court held that the right to live with human dignity enshrined in Article 21 derives from the directive principle of state policy and therefore includes protection of health. In State of Punjab versus Mohinder Singh Chawla, it has also been held by the Supreme Court that the right to health is integral to the right to life and the government has a constitutional obligation to provide health facilities. In order to successfully argue that a medical professional cannot discriminate between patients based on the disease they are suffering from, their socio-economic background, etc., it must be duly noted that since it is the constitutional right of every citizen of India to be provided with the proper healthcare facilities, including a concrete pandemic plan. Since pandemic planning is necessarily inclusive of establishing an adequate number of hospitals and staffs funded by the state, thereby it helps in minimizing out-of-pocket medical expenses. The government policies vis-a-vis healthcare services has mandated entitlements under the minimum needs program started with the 4th 5-year plan. Each district should have a civil hospital, a primary health center in rural areas for each 20,000 to 30,000 population depending on population density and difficulty of terrain, and 5 such units supported by a 30-bedded community health center (CHC), a sub-center with 2 health workers for a rural population unit of 2,500 to 5,000 population, and similarly a health post for 50,000 persons in urban areas. But the real situation consists of a notable shortage of civil hospitals in districts. The situation regarding PHCs varies a lot across states, from 1 per 7,000 rural population in Mizoram to 1 per 1 lakh in some districts of the Empowered Action Group (EAG) states. The villagers deprived of this entitlement cannot go to the courts demanding the right to a public health center for their area because such a legal backing does not exist. Further, in many states where this ratio is honored for PHCs or CHCs, adequate staff, medicines, diagnostic facilities, maintenance budgets are often not available to assure that proper provision of services is available to the people accessing these services. This is gross iniquity, but there is no law at present that can help address it. Due to the lack of preparedness, India already has had to face tremendous stress about COVID-19. On March 1st, 2 days before the World Health Organization spoke of a global shortage of personal protective equipment (PPE), India had no PPE coveralls suitable for COVID-19 in the country. The entire requirement was being met through imports. It is of utmost importance to acknowledge that with the shortage of doctors and healthcare professionals in India and all around the world, their foremost well-being is the priority. It can be reasonably said that if they are provided with adequate and, if possible, better resources, their reasons for the unwillingness to serve will be minimal. The state, in order to secure its citizens, must first provide proper professional training as to how the professionals can act in a crisis situation as a part of a MBBS student's curriculum. Since the state during this outbreak is managing the treatment of its citizens, every healthcare worker who is assigned with this job must be held as working in the capacity of a government employee. Hence, the non-fulfillment of such duties must be taken as a violation of Article 21 done by the state itself, exempting the healthcare workers of any individual liability. For the sake of rebutting the argument that since the COVID-19 outbreak is a national medical emergency, we must understand the extent of the term emergency as per the provisions of the Constitution of India. Under Article 358 of the Constitution of India, fundamental rights are suspended, and Article 359 makes provisions for the suspension of freedoms mentioned under Article 19. Prior to the 44th Amendment, Article 352 categorized the terms external disturbances and internal disturbances, allowing it a wide scope for interpretation. For the sake of clarity, it must be scrutinized whether a medical outbreak can remotely be a state of emergency. With the 44th Amendment Act only, Article 355, which showcases the duty of the Union to protect states against external aggression and internal disturbances, still provides a wide scope for the recognition of a pandemic as a natural calamity and therefore a state of emergency. The report of the Sarkaria Commission on the provisions of the Constitution had observed, with reference to the emergency provisions, that the scope of the term internal disturbance is wider than domestic violence under US and Australian constitutions. It conveys the sense of domestic chaos, which takes the color of a security threat from its associate expression, external aggression. Such a chaos could be due to various causes. Large-scale public disorder which throws out of gear the even tempo of administration and endangers the security of the state is ordinarily one such cause. Such an internal disturbance is normally man-made, but it can be nature-made also. Natural calamities of unprecedented magnitude such as flood, cyclone, earthquake, epidemic, etc. may paralyze the government of the state and put its security in jeopardy. Therefore, an epidemic, since a natural calamity, can result in the declaration of national emergency. But two things shall be noted at this point. Firstly, the President has not declared a proclamation of emergency due to COVID-19 as of now. And secondly, under Article 359, however grave a situation may be, even when a proclamation of emergency is in operation, the President may by order declare that the right to move any court for the enforcement of such of the rights conferred in Part 3 shall be suspended except Articles 20 and 21 of the Constitution. And if done so, mere immunity under Section 4 of the Epidemic Diseases Act 1897 shall not prevent the state from being legally liable if it deprives its citizens from availing their right of health and proper medical treatment under Article 21 of the Indian Constitution. As a conclusionary comment, I would refer to Heidi Maum's work where she urged changes in the employment contract where some national preparedness plans appear to favor flexible working and special leave agreements between staff and management to cover pandemics and other emergencies. What is clear is that national preparedness plans should address the issue of attendance at work explicitly rather than adopt a wait-and-see approach. Regardless of its attractiveness in the short term, to what extent the latter option could lead to chaos when disaster strikes and undermine the success of the plans is of no doubt today. Thank you all for listening.
Before we conclude, we would like to thank all members of the committee who have helped and supported us through this venture. If you enjoyed listening to our podcast, consider following us on twitter.com/CULawJSC and on Facebook at www.facebook.com/CULawJSC. The full transcript of this episode of the podcast can be accessed at its official Medium page at www.medium.com/illegalitypodcast. Thank you everybody, and please stay tuned for details on our next episode.